Hi, I'm Mason Waring, and this is Leah Small. We're attorneys at CCK. Today, we're going to talk about any occupation definitions of disability and long-term disability policies. We're going to talk about how you could meet any occupation definition of disability, and we're going to talk about some variations, including the gainful components that you can find in some of these definitions of disability. So, Leah, let's get started. What do we mean when we say any occupation definition of disability?
Well, just as it sounds, basically to meet the any occupation definition of disability, a claimant must be disabled from any occupation whatsoever, not just the occupation they were doing at the time they became disabled. Oftentimes under long-term disability policies, especially ones you obtain through employment, your claim may start off under an own occupation definition of disability, but it'll then transition to the any occupation definition usually after 24 to 48 months. And so you have to demonstrate that you meet that new definition of disability in order to continue receiving benefits. It's really important for claimants read policy carefully to make sure you understand the definition of disability. Does it change at any point to become the any occupation definition of disability? Because that's going to tell you what do you need to establish to receive benefits under your policy.
Great. And what are the different types of variations that we see?
So you can have a very broad definition that essentially says if you can do any job whatsoever, you're no longer disabled and entitled to benefits. But oftentimes we'll see any occupation definitions that are a little narrower, a little more specific. For example, it might say if you are unable to perform any occupation that you're qualified for, given your education, your training, your past work experience, then you're still entitled to benefits. Alternatively, we sometimes see definitions that have that gainful component you mentioned, in that the definition will examine, are you able to perform an occupation that earns you a certain percentage of your pre-disability earnings? And if you can work but can't earn above that gainful threshold, then you may still be considered disabled in the terms of your policy entitled to benefits.
How does the concept of working reliably and consistently fit into the any occupation definition of disability?
It's a great question. So oftentimes you may see, I could work one day, but it'll cause increased pain, it'll cause increased fatigue, and I can't do it day after day, week after week.
Or the endurance factor too.
Right, or even a full day may be difficult for you. And so, we often argue that if you can't perform that occupation reliably and consistently, then the claimant should be considered disabled and entitled to benefits under the terms of the policy, again, even if they could do it for one day or even a week. If you're not a reliable, consistent employee, you're not going to be employable.
Yeah, and that concept, you won't find it in all policies. It's kind of almost a practicality that comes about, and so that's really the benefit of having an experienced long-term disability lawyer on your side. Is to we take our experience, we look at the law, we look at your policy, we look at the facts of your case, and really try to put it all together for you. If you have questions with your long-term disability claim, if you've been denied, reach out to us. It costs nothing to see if we can assist. Our number is 401-331-6300. You can find us online at cck-law.com. Please like and subscribe. If you have any ideas for future videos, please leave us a comment. Thank you.